The day my mother-in-law handed me a pen and said, "Just sign it, sweetheart. You're too emotional to be making financial decisions right now." I almost believed her. Almost. In my line of work, you learn very quickly that the most dangerous documents are the ones people ask you to sign without reading. I'm a paralegal. I've spent 7 years reviewing contracts, estate filings, and power of attorney forms for a mid-sized firm in Mississauga. I know exactly what a signature can cost you. And sitting at my mother-in-law's kitchen table, 43 days after burying my husband Daniel, I knew precisely what she was trying to do. I just didn't let her know that I knew. My name is Rachel. I was 31 when Daniel died. A highway accident on the 401 inches January black ice, a transport truck, and a phone call I will never be able to unhear. We had been married for 4 years. We had a joint mortgage on a townhouse in Brampton, a dog named Biscuit, and a life insurance policy through Daniel's employer worth $380,000. We had no children. We had no will. That second part is what his mother had been counting on. Margaret, my mother-in-law, had never liked me. I was not the woman she had imagined for her son. Too practical, she once told him. Not warm enough. What she meant was that I asked questions she couldn't answer, and smiled politely when she expected me to flinch. Daniel used to laugh about it. "You're the only person who has ever made my mother nervous," he told me once. I took it as a compliment. But Daniel was gone now, and Margaret was no longer nervous. She was moving fast. Within 2 weeks of the funeral, she had called 3 times to discuss the estate. Within 3 weeks, her son, Daniel's older brother Kevin, had driven up from Hamilton twice to check on me. By the end of the 4th week, Margaret had suggested, very gently, that I was struggling too much to manage everything alone, and that the family wanted to help. The family, as if I was not his family. I want to be honest about those first weeks, because I think it matters. I was not okay. I came home every evening to a house that still smelled like him. I found his coffee mug in the drying rack, and could not put it away for 11 days. I cried in my car in the parking garage at work because I did not want my colleagues to see me fall apart. I was grieving, genuinely and completely, in the way that you grieve when the person who made your life make sense is suddenly just gone. But grief does not make you stupid, and I knew what a power of attorney form looked like. The document Margaret slid across the table to me that Wednesday evening in February was a continuing power of attorney for property. It had been prepared by a notary in Oakville, not a lawyer, a notary, which told me a great deal about how carefully it had been drafted. It named Margaret and Kevin as my attorneys, jointly, with full authority to manage, sell, and distribute my property, in the event that I was unable or unwilling to do so in a timely manner. Unable or unwilling. That phrase was doing a tremendous amount of work. "It's just so you have support," Margaret said. She was pouring tea she knew I didn't want. "Kevin and I can handle the paperwork, the insurance claim, all of it. You don't have to carry this alone, Rachel. Daniel would have wanted us to take care of you." Kevin nodded from across the table. He had the same jaw as Daniel, and none of the warmth. "It's standard," he said. "Everyone does this when there's an estate to settle." It was not standard. It was not remotely standard. A continuing power of attorney for property gives the named attorneys access to everything: bank accounts, investments, real estate, insurance proceeds, everything. And the triggering language in this document, "unable or unwilling to act in a timely manner," was vague enough that a creative interpretation could activate it almost immediately. If I signed this, Margaret and Kevin could theoretically claim access to Daniel's $380,000 life insurance payout before I ever saw a dollar of it. I picked up the pen. I looked at the document. I looked at Margaret, who was watching me with an expression she probably thought looked like compassion. "Can I take a few days to read it over?" I asked. Her face didn't move, but something behind her eyes did. "Of course," she said. "Take all the time you need." I took the document home. I photographed every page. I sent it to a colleague I trusted, a senior paralegal named Donna, who had 22 years of estates experience and absolutely no patience for nonsense. Her response came back within the hour. "This is predatory. Do not sign this. Call an estates lawyer tomorrow morning." I already had one in mind. "Here is what I want you to understand about the next 3 weeks." I did not panic. I had one conversation with myself in the bathroom mirror, the night after I got Donna's message, and I said, out loud, to my own reflection, "You have done harder things than this." Then I made a list. The list was practical. Item 1. Retain an estates lawyer immediately. Item 2. File the life insurance claim in my name alone, before anyone else could interfere. Item 3. Understand exactly what rights I had as a spouse with no will. Item 4. Document every contact Margaret and Kevin made with me from this point forward. Item 5, which I added later. Give them exactly enough rope. My estate's lawyer's name was Patricia. She was 54, wore sensible blazers, and had the kind of calm that comes from having seen every possible version of family greed. She confirmed what I already suspected. In Ontario, when a spouse dies without a will, the surviving spouse has a preferential share under the Succession Law Reform Act at the time, $350,000 off the top of the estate, and an equalization of net family property under the Family Law Act. The life insurance policy, which named me as beneficiary directly, bypassed the estate entirely. It was mine. Margaret and Kevin had no legal claim to it. Then why the power of attorney? I asked. Patricia's expression was exactly what I expected. Because if you had signed it, you would have handed them the ability to interfere with your claim and potentially delay or redirect the payout long enough to create legal complications. It's a tactic. Uncommon, but not unheard of. What if I let them think I'm still considering signing? She looked at me for a moment. What are you planning, Rachel? I want to know the full scope of what they're trying to do before I shut it down. If I refuse and lawyer up now, they'll stop. And I won't know what else they had in mind. Patricia leaned back in her chair. You have 7 days before the insurance company processes your claim and the funds are dispersed. After that, the policy proceeds are in your account, and there's nothing they can do. 7 days. 7 days was enough. I called Margaret that evening. I told her I had read the document and had a few questions, but that I was leaning toward signing. I told her the grief was making it hard to concentrate, and that honestly, having support sounded like a relief. I made my voice sound tired. That part was not difficult. She was warm in a way she had never been before. She told me she was so glad I was coming around. She said Kevin was relieved. She mentioned, very casually, that she had spoken to someone at the insurance company, just to ask some general questions, she said. Nothing official, and that she wanted to make sure the claim process went smoothly. I wrote that down. Date, time, exact wording. Over the next 4 days, I learned more about what Margaret and Kevin had planned than I think they intended me to know. Margaret called daily, each time dropping a little more information the way people do when they believe they've already won. She mentioned a financial advisor Kevin had been speaking to. She mentioned a property in Prince Edward County that Daniel had apparently always talked about buying news to me, and wasn't it a shame that his share of the estate couldn't go toward something like that? Something that would honor his memory. She mentioned, once, that the townhouse in Brampton had probably appreciated significantly since we bought it, and that I might be better off somewhere smaller, less full of memories. She was building a case, piece by piece, for why my assets should move in her direction. On day 5, something shifted. Kevin called me directly, which he rarely did. His tone was different. Less patient. More pressured. He asked when I was planning to sign the document. He said Margaret was anxious to get the estate sorted. He said. And I wrote this down word for word. The longer this drags out, the more complicated it gets for everyone. That sentence told me everything. They had a timeline. Something was creating pressure on their end that had nothing to do with my grief. I called Patricia. Find out if either of them has any outstanding debts or financial proceedings, I said. Anything registered in Ontario. She called me back in 2 hours. Kevin had a judgment against him. A creditor had obtained a court order for $47,000, stemming from a failed business venture 18 months earlier. The judgment had not yet been enforced, but it was registered. If Kevin suddenly came into a significant sum of money, that creditor could move to collect. That was the pressure. Kevin needed money that couldn't be traced directly to him. A joint power of attorney, with Margaret as the more visible name, was a way to access funds with some degree of distance. I sat with that information for a long time. Then I called Margaret and told her I was ready to sign. I suggested we meet at my townhouse that Saturday. I said I wanted to do it somewhere that felt like home, somewhere that felt like Daniel. Margaret said of course, whatever made me comfortable. She sounded relieved in a way she couldn't quite contain. I spent Friday preparing. I am going to be very clear about what I did, because I want you to understand that none of it was illegal, none of it was deceptive in any way that the law would not entirely sanction, and all of it was absolutely intentional. I called the insurance company and confirmed my claim was processing on schedule. The funds would be in my account by end of business Friday. I asked them to note on file that I had made no inquiry about changing beneficiary designations, and that no third party had been authorized to speak on my behalf. I drafted a letter. Patricia reviewed it, addressed to Margaret and Kevin, documenting every contact they had made since the funeral, every statement Margaret had made about my assets and the property, Kevin's comment about things getting complicated, and Margaret's admission that she had contacted the insurance company without my knowledge or authorization. The letter noted that any further attempt to interfere with my estate, my insurance proceeds, or my property would be treated as harassment and reported to the Law Society and the relevant financial regulatory bodies. I printed 2 copies. I put them in envelopes. I also made one other arrangement. I asked Donna to come over Saturday morning and stay in the kitchen. She was not there as a witness in any official capacity. She was there because she is 6 feet tall, has the energy of someone who has never once been intimidated by anyone, and I wanted a friendly face. And yes, I wanted someone else in the house. Saturday morning, Margaret arrived at 10. Kevin was with her. They brought muffins from a bakery in Oakville Blueberry, which Daniel had loved. I noticed that and I let myself feel it for exactly 3 seconds, and then I put it away. We sat at my dining room table. Margaret had brought her copy of the Power of Attorney. She had a pen ready. "I'm so glad you decided to do this," she said. "I know it wasn't easy." "It wasn't," I said. "You're right about that." I reached into the folder in front of me. I took out the 2 envelopes. I slid one to Margaret, and one to Kevin. Kevin frowned. "What is this?" "Read it," I said. The kitchen was very quiet. I could hear Biscuit's nails on the hardwood floor in the next room. I watched them read. I watched Margaret's face go from confusion to understanding to something that was not quite panic but was adjacent to it. I watched Kevin get to the paragraph about his judgment debt and go very still. Margaret looked up first. "Rachel, this is we were only trying to help." "I know that's what you told me," I said. "But I'm a paralegal, Margaret. I've been one for 7 years. I know what a continuing power of attorney for property does, and I know what the triggering language in yours was designed to accomplish. I also know that you contacted my insurance company without my authorization, which is something they're aware of and have noted on my file." "We're family," Kevin said. His voice had an edge in it that he was trying to keep under control. "Daniel was my family," I said. "The 2 of you are people I was kind to because he loved you. That's different." I took the power of attorney document off the table. I didn't make a show of it. I just picked it up and placed it back in Margaret's folder. "The insurance funds were deposited to my account yesterday evening," I said. "The townhouse is in my name and Daniel's estate. I've retained an estates lawyer, and I'll be handling everything through proper legal channels. If either of you attempts to contact my financial institution, my insurance company, or any legal body regarding my assets, without my explicit written consent, I will be filing a complaint with the Law Society regarding the notary who drafted this document, and I will be pursuing the matter further from there." Margaret opened her mouth. She closed it. Kevin said, "You were never right for him." I stood up. "Thank you for the muffins," I said. "I'll let you out. I have thought about that moment many times since, about whether I should have felt satisfaction or sadness or something more complicated. Mostly what I felt was tired. The particular exhaustion of having held yourself together through something that should have broken you, and finding yourself still standing on the other side." They left. Donna came out of the kitchen and hugged me for a long time without saying anything, which was exactly right. The estate was settled over the following months without incident. Patricia was thorough and efficient. Under the Succession Law Reform Act and the Family Law Act, my preferential share and equalization rights were clear. The townhouse equity was calculated. Daniel's small RRSP transferred smoothly, and the $380,000 from the insurance policy sat in a high-interest savings account while I figured out what came next. Kevin's creditor, as far as I'm aware, eventually enforced the judgment through other means. That was not my problem. And I want to be precise about that. It was never my problem. I had been told, in various ways, that loyalty to Daniel meant absorbing consequences that had nothing to do with me. It did not. Loving someone does not mean inheriting their family's financial crises. Margaret sent me one letter, 3 months later. It was 2 paragraphs. The first paragraph said she was sorry for how things had unfolded. The second, I kept the watch. It was on his wrist when I married him. I sold the townhouse in September. Too many quiet evenings, too much of him in the walls. I bought a condo in downtown Hamilton, smaller, yes, but mine, in a way that place had never quite managed to be. Biscuit adapted immediately, the way dogs do, with a completeness of spirit that I found genuinely instructive. I still work in the same firm. I got my paralegal license renewed and started specializing more heavily in estates and family law. Donna jokes that I went from being good at my job to being personally motivated, which is accurate. I don't know if what I did was brave exactly. I knew the law, I had access to the right people, and I had just enough emotional distance from the situation even in the middle of grief to think clearly. That's not bravery. That's just using what you have. But I'll tell you what I learned. For whatever it's worth to you, grief makes people believe you're vulnerable, and sometimes you are. But vulnerability is not the same as helplessness, and the two are very frequently confused, usually by people who are hoping you won't notice the difference. I noticed. Daniel used to say I was the most practical person he had ever met. He meant it as an endearment. I used to tease him about it, tell him that practical wasn't exactly romantic. But sitting across from his mother and his brother with their envelopes and their muffins and their careful, patient greed, I thought. He was right. He was completely right, and I thought about how much I wished I could tell him so. I burned the copy of the power of attorney document the same evening. Outside on my little condo balcony, in a metal bowl, watching the pages curl and go dark. It took about 45 seconds. Biscuit watched from inside, confused by the smoke but too polite to bark about it. The bridge was gone. Whatever had been waiting on the other side of it, the version of my life where I had signed that document, where I had believed that surrender was the same as grace, could not follow me here. I was 31 years old, and I was starting over. And for the first time in a long time, I was doing it entirely on my own terms. That was enough. That was more than enough.